Yeah. It's on now. Okay. I guess we're not on the record. Now we are. So again, just make sure you are, if you're logged in by a telephone, that you send me an email with your telephone number so I can let me know you attended so I can check you off the list, because it will be on the Excel sheet that comes along with this. Okay, so it's 10 o'clock and we'll go ahead and get started. I wanted to welcome everyone for coming today. I do appreciate it. The board has discussed this issue on quite a number of occasions, and so we wanted to offer this session for you as a manager or supervisor or administrator, so you would understand the board's position on what you should or should not report. So to begin, this continuing duty to report, your legal obligation basically falls into a couple of statutes, and I wanted to first begin with saying that, as you know, I am the executive director, and information contained in this presentation does represent common issues seen by the board, but names and locations were eliminated for this presentation. Some of the objectives, we'll be doing some cases here in just a minute, but basically we're going to use simulated cases to determine if there's a violation and should it be reported. We'll also look at the rules to specifically see if there's any statutory violation that occurred, or at least discuss it. We won't go into all the specific rules. So just remember, the board does look at errors as a human thing. We all make errors, and we can't hold people. We hold people responsible for their actions, but at the same time, we also realize that sometimes mistakes are made when people are running around trying to resolve issues, and we're not looking to take anyone's license just at a whim. We want to make sure that if a license has to be revoked, suspended, or put on probation, that we have due cause. But what we're seeing is that sort of a conflict of what you should and shouldn't report, or maybe should you report everything. And so we want to clarify a couple of things. First, we have both an ethical and legal obligation here at the board to look into matters that are reported to us. But the legal and ethical matters aren't the same as your policy violations. And so that's where there's, I guess, maybe some confusion. 21 NCAC 61.0308, continuing duty to report, requires that all supervising respiratory care practitioners are under the continuing duty to report to the board any and all terminations of respiratory care practitioner for violations of the Practice Act or board rules, and violations of the Practice Act or board rules by any respiratory care practitioner under his or her supervision. Sort of seems redundant, but sometimes you may not terminate somebody, but there's still a violation. So let me explain what report means. Report doesn't mean file a complaint. Report means you report it to the board, and we'll have a discussion, and we'll determine whether or not a complaint needs to be filed based on our discussion. So that's where the violations of the Practice Act. So you might report somebody for a violation, but you're not going to terminate. And the first question I'm going to ask you is, why aren't you going to terminate? And you may say to me, well, we didn't feel that it rose to the level of termination. It was a violation of our policy. And, and we would just discuss the particulars and determine whether a complaint needed to be filed. And we'll discuss a few of these so you can see clearly in some cases they should be filed, and in other cases maybe not so clear. In some cases they are filed and nothing comes of it, but sometimes we just have to go through the process. So here are the case profiles. So if you have questions, I'll stop along the way as we go through different cases and see if you have any questions. And I would encourage you to ask questions, because that would be the way that we'll be able to determine whether or not this is effective. Here are a few things that you should be aware of as far as what we are seeing. First, we're seeing things like failing to create and maintain a respiratory care record. We're seeing willful making or filing a false report, deceptive or fraudulent representations, most commonly, though, unprofessional conduct, which all of these would fall under, and then violations or violating the code of ethics. Again, many of these would fall into that as well. And then, of course, substance use issues. In fact, you could take all of everything that we have, and it would fall under both of these two top categories. But these are sort of the unprofessional conduct and violating the code of ethics is our statutory requirement that we have to meet. The other ones that you'll see on our rules, there's about 34 different potential violations fall under those two elements. So we've got the statutory, which is meaning that it's actually listed in our statute, and then we've got those that are listed in our rules that further define that. So case number one, copy and paste. So many of you use systems that allow for, whether it's a ventilator check or some type of other assessment, that allows for copy and paste. If you allow it, that's fine. It's not a problem. The problem comes in is when you have to terminate somebody for false documentation. And the question I'm going to ask you when you call in is, was the RCP terminated for the actions that they took? And if your answer is yes, we'll start with, okay, what does your policy say? And you say, well, you know, we don't allow copy and paste, and it was a violation of that. And then the next question is, well, was that what they copied and pasted false documentation? Because we want to know whether or not there was an ethical breach or a legal breach, because it could be, obviously that would be both. Because if there's intent behind that, meaning that they intended to do something that, they intended to do it because maybe for whatever reason, maybe they were busy and thought that they'd get back to it later, but they copied and pasted so they could get on with it. But it turned out that what they were charting actually wasn't what was on the ventilator. But that usually doesn't happen unless somebody uses that copy and paste feature. But most commonly we see that with written work, where people will copy down the last ventilator check rather than checking the ventilator. There's a number of things that could be going on there, but the bottom line is we're asking you, is it a policy violation for them to copy and paste? But if you tell me no, they can use copy and paste, but they must verify the values. So the question is, then what happened with the events? Where did this go? How many times did this happen? Was it a one-off? Because usually people don't get terminated for a one-off violation, for a policy violation. And if that's the case, then there's probably not enough there for any type of investigation. But if this was something that was egregious, then of course we would investigate. So what we would have is a conversation that you're reporting it to us. And then I would tell you, well, it sounds like we need to go ahead and file a complaint. So why don't you go ahead and do that on our online system? Because the board needs to look at this a little further. And the reason I'm bringing copy and paste up, because that's a really common thing across the United States, that copy and paste is a problem. Some hospitals don't allow that feature, others do. It can be in your policy, you can allow it. We're not telling you you can or you can't. But if you do, be careful, because sometimes things happen because it's practice but not policy. So for example, here's a good example of this, and we see this either done by hand, but now more commonly we see it done by iPhone or other means of electronic means. And if it's done by, of course, iPhone, that potentially opens up possibly a HIPAA violation. But let's stay with this. So the RCP in some way records the ventilator settings, but they have to enter them into the EMR. And maybe they do that remotely because they don't have time to do it then. I'm not really sure why personally, but let's just say they do. We've had this happen where they would go to maybe another computer, maybe it's outside the unit, and they chart. That's what we've been told. I would personally find it odd to chart outside of the patient area, but that's just me. And again, the therapist that this particular situation happened, they basically wrote down the ventilator settings that was, say, the ventilator settings that were prior for the patient to go on, or I think they were on the ventilator, they were taken off the ventilator, and they were being transported and put back on the ventilator. So they wrote down the previous settings, and that's what they charted in the chart, but the settings had actually changed. And by the time they got to the unit, so they weren't really charting the ventilator settings, the new ventilator settings, they were charting the old ventilator settings. So was the RCP terminated in this case? Yes, for false documentation. Was it a policy violation? Yes, of course. because they didn't actually check the ventilator. And that would certainly breach ethical and legal violations. Now, in the previous case, it may or may not have been because you allow it to happen, and maybe by happenstance that they didn't have any intent, but they got it wrong. In this case, maybe they had intent. We don't know. But those kinds of things have to be investigated. And again, I would ask you, did you terminate? If you did terminate, then that's reason enough to report it. Whether it's reason enough to actually investigate it, it will depend on our conversation. But in the EMR situation, there's a potential for, and I didn't bring the research into this presentation, I do have it. There are some serious breaches of information that throughout the United States, a number of studies, when they look at specific cases on the use of cutting and pasting or this type of transferring of data where information is not accurate. And I guess the worst case scenario is they don't write it down and they go to a computer and they try to remember it without any form of documentation. That's even scarier, but that happens too. Okay, so any questions about charting? We got a couple more later on. Okay, so the case of a serious disagreement between coworkers. Now, normally, somebody's having a conversation in the department and they get in a shouting match and, you counsel them, et cetera. Not something that we would necessarily deal with. But what happens if it evolves to one RCP striking the other? Whether it doesn't matter who it is, really. It certainly would be a reason for termination. It would be a policy violation, certainly. And would it be an ethical and legal violation? I think this would be an easy call. But you would probably call me and say, do I need to report it? Because it didn't involve patient care. Well, no, it does really involve professional behavior. And in this case, that's an egregious violation and it's also one that's a criminal because now they've assaulted someone and committed battery on them. And they're going to have more problems than us, or should. So that one is usually a fairly easy call. But again, that would be something that, I guess if they broke out in a fight and both were hitting each other and you couldn't determine that, so you terminated both of them, we would look into both of them to find out, first of all, what happened. But secondly, the board would probably at very least reprimand or put them on probation because they clearly have anger issues, and we would have a psychologist look at that because we can't have therapists not only arguing like that, but striking one another. That would obviously be the most egregious one. But we do have, and that's only happened once, but it wasn't a therapist on the therapist. It was a different situation. We have had a number of cases where therapists disagree with each other and they argue. Well, an argument isn't a reason to report someone, but what if you terminate them? And what if you've got two that are obviously you have to have two to have the argument, but let's say you have the two that are in argument with each other and it escalates, but it never gets to obviously hitting each other. But you decide because one therapist has a history of not getting along with people that you're going to terminate that person, and you would be certainly right in your right to do so. But the other therapist, who's typically a good therapist, who's never gotten in an argument, you would not terminate. And that makes sense as well. So we would deal with it by asking you, why did you terminate the therapist? And you would tell us and would say, okay, well, if their actions, their prior actions, what were their prior actions that led up to that termination beyond the fact that they were arguing? And they were, let's just say they were minor policy violations, but it's something that was documented. And patient care had never been affected, but they were just maybe an adversarial type person, somebody that people just couldn't get along with. And you've written them up, say, 3 times, and now this is their final time. They got in an argument with the therapist, a colleague, and you just had it and said, okay, we're done. I would say, well, it is your policy violation, and yeah, it's unprofessional behavior for them to be arguing, but it may not, we wouldn't have necessarily a legal violation for someone who is disagreeable necessarily. I mean, we could look into it if there's enough evidence, but oftentimes there's not enough evidence. So again, if we would have that conversation would reveal what we would need to do, and I would say, well, maybe we should go ahead. Maybe you should go ahead and file a complaint in this case. Certainly, if it comes to blows, that goes without saying. Here's another charting issue. Any questions about arguments, fights? I think those are usually pretty clear, and they're HR issues, mostly. Just want to make sure here. So how many people we got on board? Wow, we have a lot. Okay, so let me know at any time if you have a question. I can't see you, unfortunately, while I'm presenting, but if you want to just chime in and ask a question, I would appreciate it. Okay, so case of forgetting to hit save. This has happened a couple of times with some of the older therapists who aren't as tech savvy, and this is a situation where it's maybe, but you terminate the person. Let's just say you terminate the person for the violation. Well, the statute says you must report them if you terminate them, right? But does it constitute a violation of the Practice Act? Let's see about that. So obviously that's going to be a policy violation because they didn't document 3 treatments. You've basically accused them of falsifying documentation because, or not fault. Well, it depends. Not falsifying documentations, but they performed 3 of the 11 treatments. That means that they, in this case, documented 3 of the 11 cases, but the other 8 of the treatments, they claim they did, but there's no record of it. In this case, it would constitute a complaint, and in this case, it did constitute a complaint. So what did we do? Well, after the investigation, or during the investigation, and really at the point where we saw clearly that the person probably did have all the treatments completed, but they failed to hit save in this case, or they didn't go back and make sure they had entered. So in other words, they typed it in but didn't actually save it. Their explanation seemed logical. The board, I think, in this, well, we've had a number of these. So I think the board in one case decided based on the evidence that they could present and, to us, that it was clear that they just didn't understand how to use the computer system or didn't know how to check themselves. And clearly this therapist didn't have any business working in an environment where they couldn't operate, the charting system very well. And there's really no excuse for them to say, well, I'm an older therapist, I can't do that. Well, no, they have to be able to do that. They have to be competent in all aspects of their job. So in this case, maybe we did, maybe we didn't actually go ahead and reprimand this person. We didn't. They wouldn't rise to a level of probation and certainly not revocation because it didn't seem like there was intent to do anything, but there was enough there that the board needed to act, which then also required some additional competency training that the board can enact when they engage in a consent order with the board. And I think in a number of these cases where we see competency issues for this, that's what we would do. We've had competency issues in other areas, such as airway management or ventilator management, where we've required them, even if they're not on probation, to complete certain courses to ensure that they have an update on that information. Okay, here's a different one. I get this call a lot. I have a therapist who's not showing up for work. Do I need to report them? Well, I'm going to ask you the same question every single time. Did you terminate them? And if the answer is no, then I'm going to say, then you don't have to report them. Because showing up for work or not showing up for work is not a violation of our, even though it's unprofessional technically, there's nothing that we could really do legally because we can only deal with them generally when they are actually engaged in the practice. By not coming to work, they're not engaged in the practice. But there are nuances to that. It is something that would be concerning, obviously. But if you didn't terminate them, there would be no reason to report it. in this case, because that's an HR issue. But if you did terminate them, it's a termination for a violation of your attendance policy. So it might be a multitude of tardies and absences, whatever, and you decide that's it, we're done. Many people don't think about the other things that may have led up to that. And we're going to get into some of the other additional things that if we did investigate this person because you terminated them and because we thought maybe what you told us there was something that didn't add up, and we go in and start evaluating or investigating, we might find other things, and we have had that happen before. So if it's just absences, tardies, I can't say it's not a big deal. I mean, personally, it would drive me crazy as a manager, and I've been there, so I understand. But it doesn't constitute a legal violation for our statute. However, this does. I think this is pretty clear to all of us. If they left work without permission, you would terminate them, I'm assuming. I don't think anybody wouldn't terminate them, but nevertheless, I've had people call me and say, I've got a therapist who left, who clocked out and went home and didn't give report. Well, that's a clear violation of not only your policy, but our ethical and legal violations. And yes, we would ask you to file a complaint. We've had a number of these. In one, I think it was last year, we had like 3 in a row, and they basically just decided that respiratory therapy was not for them, and they just walked out. In at least 2 of the cases, we had them surrender their license very quickly because we didn't want that individual even contemplating going back to work, having basically abandoned their patients. And if they ever want their license back, and it's a possibility if they can somehow show they would never do that again, it's a much more arduous process, and the board does not have to renew their license. It's an alternative to revocation. Revocation, of course, is permanent unless there's evidence that can overturn that revocation. So I think this year, last year now, we had at least 3 of these. One of them was actually somebody we had seen at the board before, and we had a prior discussion with this individual just 3 months prior to them walking off the job. We warned them because they were telling us that there was, they didn't like where they were and all this stuff. And we were saying, well, just whatever you do, give your notice and leave, under good circumstances. Despite all of our warnings, they did that. And this individual is now coming back before the board for a second and third time. So we try to head off these issues if we can. So the sooner we know that somebody has done something, the quicker we can usually nip it in the bud, as Barney Fife used to say. And we would like to do that because we don't want these behaviors to continue, because that destroys the morale of your entire department and the profession for that matter. So this one's pretty straightforward. I don't think anyone would question that one. So another common thing that we see are when they test positive for substances that impair judgment, whether it's alcohol, THC, or prescription drugs. Alteration of judgment or impairment of judgment is our threshold. So, for example, I think most everyone has a 0 tolerance for alcohol. I know a few hospitals have, if it's below a certain alcohol content level in their blood, they don't consider it a policy violation. I'm not sure if you have that policy. I was surprised to find that out personally. But again, if you're calling me to ask me whether you should report this person, if you've terminated, and the answer is yes. But if you tell me, well, no, we're not going to terminate them. In this case, they went into EAP, then they've clearly violated your policy. But because you have the policy of, I guess you could say a humane policy of trying to save your staff, and I think that's a good thing. If they've entered an EAP, it makes it a lot easier, and certainly the board would agree with that. However, it does need to be reported, and it needs to, a complaint needs to be filed, because we need to get that person under contract, or what we call a consent order. And there are two consent orders that we use for this. One is intervention program, which this person wouldn't qualify because they showed up for work and they tested positive. So they were at work with a high level, well, any level of alcohol. The alternative program, which is a much more stricter program, which can be probation up to 36 months and significant monitoring, may exceed even what your EAP does. And so this allows us to ensure that they have adequate supervision for the period of time. Now, some experts recommend 5 years if this happens. And so the board may change its stance on this, but right now the maximum is 3 years probation for the alternative program for an individual like this. We did have an individual who tested positive either last year or first of last year, the end of 2019, end of 2019, and then again in 2020. Their first blood alcohol level was 0.268 at the end of their shift. Can anyone tell me if you would, you can put it in the chat box if you want to, or you can chime in, would you terminate that person for an alcohol level that high? Anybody?
Yes, definitely.
Yeah, I hear definitely.
Yeah, I believe we would, yes.
Okay. Yeah, I was quite shocked when I saw that blood alcohol level. And I asked, did you, I'm assuming, and I even said, I'm assuming you terminated. And they said, no. I said, really? I mean, I was literally shocked about it. And everybody, I think, is in agreement that is yes and absolutely. So anyway, because they put them in EAP, we decided that, okay, we'll put him under alternative program under the strictest guidance, under the strictest supervision. After signing the consent order, within 30 days, he broke the consent order and broke their policy again and was subsequently terminated. Now, that would have been no surprise probably to any of you to hear that, because somebody with an alcohol level that high after the end of their shift, what does that tell you? How are they delivered? Yeah, I agree with you, Jim, on that. I think I have no idea, honestly. But as we talked about it, you've heard of functional alcoholics, and this person was a functional alcoholic, basically. Yes, they drank during their shift clear, and absolutely. And that's what the scary part was how much alcohol was in the system, both times, actually. So this person is no longer working in the field, just so you will know, not because we necessarily had a revocation of the license, but because the violation of the consent order, we moved to immediate suspension, and then their license expired. So that individual will not be able to come back to work or get a license until they come before the board and go through a hearing. So be assured that that's one of the reasons you need to report. Because in this case, if they read the first part of that statute or that rule, they wouldn't have reported because they said, well, I didn't terminate them. But the second part of that says if there's a violation of the rules. So the violation of the rules then means, in this case, they were using substances that altered their judgment, and therefore that is a direct violation of the rules, unprofessional conduct, and certainly a ethical and legal violation. Okay, so that was one of the more egregious ones. And I don't want to say this one is not egregious, but it's somewhat more difficult to say how egregious it is for one reason. THC comes in all sorts of CBD products. Now, technically, it's supposed to only be at a 0.03% level, but we're seeing a lot of data that suggests that maybe CBD oil has a higher level than is reported by the manufacturers, given the, now North Carolina has a pretty strict guideline for THC in CBD oil. Most people aren't aware, but we do have a position statement on this that was released back in October. So on our position statement page, you can go and find that. But ultimately, the way we're going to handle THC is most hospitals terminate immediately for THC. Regardless, I haven't had any of them put them in EAP for this. But if they did, we would follow the same protocol. But in this case, it is a policy violation, it is a legal violation, and certainly ethical violation. So because you're terminating, you had to report them. But if you didn't terminate them, just like the alcohol situation, you would need to report them because it is a violation. Now, the question is it impairing judgment? And that's where the big argument is now, because many people will tell you, and this argument is going all over the country about this with licensing boards. Some licensing boards allow a certain level, but we don't know what level constitutes impairment of judgment. But certainly if somebody has been tested because you suspect something, that means their behavior has changed enough. And if their behavior has changed enough, then their judgment is potentially altered. So that's something that's has to be reported. A complaint has to be filed. And then we investigate. There occasionally, if they can prove that they've been taking CBD oil and they've got either a prescription for it from their doctor, because my wife actually was prescribed CBD oil by her psychiatrist. So if they can provide a prescription, that's a little different than somebody who's obviously smoking pot, because I think there is one medication that can be prescribed as well, but psychiatrists can either recommend or prescribe other things I wasn't aware of. But in any case, the legal and ethical violation here is there. We can't tolerate people taking any types of medication that would alter their judgment. The question then becomes, what if this person wasn't an employee, but they had tested positive during the screening prior to employment? Should that person be reported? Well, the answer is yes. They should be reported, and we would file a complaint, and then we would subpoena the records to show that they actually tested positive. Now, we've had a number of these with COVID-19 because we had so many people applying for jobs. And it's very difficult because they don't provide oftentimes in the screenings the level of THC. We had one recently that this happened with, and actually I think they tested positive at work, so that was different, but they refused, they didn't test at work, they refused, they were terminated. And so the question is, should you report that person? And the answer is yes, and here's why. If that person who was terminated because they refused to test, what we can do is we can go and ask them to also test as part of the investigation. And the reason we would want to do that is because obviously if they refuse to test and say quit because they don't want to take the test, we want to know why they did that. I mean, now that's one of those policy violations that it would be hard to prove unless we have a positive test. We couldn't do anything unless we have a positive test. So recently we did that with one person, and we found, so we had a hair analysis done, and of course it popped positive. So our suspicions were revealed once we did the test. We didn't know it until we did the test, and because they didn't take the test at the hospital, we couldn't use any information from the hospital. All we could do, they could just tell us that they've basically they declined and they walked off the job. And if they had come back negative, there wouldn't have been a cause for a complaint. But in this case, they tested positive, so the complaint went forward. So it's a little tricky with THC sometimes because it oftentimes may not show up in urine, but it will show up in hair if they've been using it chronically, certainly. This one is very problematic because now more than ever we have therapists who are using substances prescribed by their physician. So oftentimes what we will see is a therapist, obviously you're going to call therapists have been terminated for cause, and the cause was they tested positive for prescription drug, or they test positive for medication that they couldn't provide a prescription for, and then we find out they have a prescription for it, meaning that at the time they couldn't, but by the time they got to us, they could provide a prescription. But in this case, it really wasn't that at all. This person was stumbling down the hallway. They were literally tripping over their own feet and slurring their speech. They had a behavior that was obviously not normal, and it needed to be addressed. So they immediately went for cause testing. And the for cause testing showed something interesting. As I said, in a lot of cases, it's because people don't have a prescription. This person had a prescription, but it was more than twice the standardized blood levels that they should have had for a therapeutic level. So at that level, then it could alter their judgment. And in which case we proceeded with an investigation because it was clearly a policy violation. They did put the person in EAP, but the individual would not agree to our consent order. And as a result, because we were going to require 36 months of probation with monitoring, because this to us seemed like, or to the board, seemed like a very serious violation potentially that could alter their judgment and potentially have a poor patient outcome. The hospital was going, in this case, going to not terminate this individual, but they eventually ended up doing so. They tried to work with them. The individual wouldn't work with us. They surrendered their license. And it was sad that it happened because I know this therapist and they were a very good therapist, but they needed this medication to function. Unfortunately, the levels of medication they needed to function also impaired judgment. So this one's always a challenge, but we try to work with therapists on any drug issue, whether it's alcohol, drugs, legal or illegal. We will try to work with them under the alternative program in order to ensure that they stay employed, but there's only so much we can do for that. Okay, before I get to, back up here. Before I get to the next ones, do you have any questions about the drug issues that we're seeing? Yeah, don't forget the synthetic urine. Yeah, we've had that happen as well, where we think it happened, but we send them to a testing center that monitors those kinds of things. Any questions about whether or not you should report violations of your drug policy? So if you terminate, yes. If you don't terminate, yes, you should report them. Okay. All right, I'll move on. All right, here's another case of false documentation. So we've got a documented 10 out of 10 aerosol treatments in the EMR, but the Pyxis only shows that they access medication for 6 patients. You terminate them, so you would then, of course, report them. But is it a violation? Well, it's a violation of the policy for sure. The question is, well, what was the explanation? And the explanation was that they had medication passed on to them, possibly from another therapist. Maybe the therapist had gotten it out of the Pyxis, put it in their pocket. The patient declined the medication, and so they just handed it off and said, they wouldn't take it. And so that could happen. And I don't know how much medication you have floating around. I know back in the day when before Pyxis, or even after Pyxis, in many cases, there was still medication that you could have access to that you could keep with you. Certainly, if you're working in the ER, we used to do that. And so somehow they were able to get those additional 6 bullets of medication in some way. But that's a policy violation. It wouldn't necessarily be legal or ethical violation because they did give the treatments, but they violated your policy, and maybe you warned them a couple of times. The alternative would have been, of course, did they false document? Did they actually give those treatments? It might be difficult to prove because they documented it. Just because the Pyxis doesn't show that they accessed all 10 of the patients, there is a reasonable explanation for that. So we'd have to look at that. But if you terminated them and you felt strongly that, in other words, in your investigation at the hospital, you found that they didn't give it, there was some way you could prove it, then we would certainly have you file a complaint. If you told me that there was no specific information that you could find, but it was clearly your policy violation and that is why you terminated them, then the answer would be no. We wouldn't proceed with an investigation at that point because, one, we would subpoena documentation and there wouldn't be anything to document. This one is a challenge as well. Sometimes we get therapists who do violate the HIPAA situation, and this isn't unwarranted that it would happen, but it's possible that it could have just been a mistake, but you have a zero tolerance regardless. And I'm not really, I know in the early days of EMR, there wasn't as big of a deal about accessing other patients because in many cases, I mean, we would have physicians ask us to look into a patient in room 100, and so we would have to access a record. Well, they didn't have an order at the time, so technically, we didn't have them on our service. But he wanted us to look at that, so we needed to look to see, what their diagnosis was and all of those things. So we look at it. Now, some hospitals are taking a very strong stance on this, and that's where it gets kind of sticky because the HIPAA ones are the least. These are the most difficult ones to actually prove because sometimes it has nothing to do with the person's intent. Other than they were maybe following what the doctor had asked. There was no order because there was nothing ordered. They were asked to evaluate the patient or assess the patient. And so the therapist goes down to assess the patient. And of course, they're not on the service. So technically speaking, that would be a HIPAA violation. But then, in other words, you terminate them for that. And I've seen this happen where therapists get terminated. And it's very difficult because it's only really your policy violation. They didn't do anything wrong because they did what the physician asked. And that's the way most of those have ended thus far. But we had one case that raised our eyebrows because this one had accessed 3 different patients within the same shift, and they were reported they were asked, should they report it? We weren't really sure based on what they were telling us. But what we found out once we did the investigation was, one, they had a zero tolerance policy at the hospital. Number 2, this therapist was not in any of these records for more than about 30 seconds, maybe even less. In other words, they got in and got out real quick once they discovered it was the wrong patient. And so it was clear that there was no intent to do anything with that information or to access it inappropriately. It just was by happenstance. So here's the thing. Be careful about this one because we would need to have a discussion. If you do not have a clear documentation that they actually have done anything with that information, meaning that is there an alternative explanation as to why they accessed it? In this case, there was. Of course, there have been cases where we had one case where this happened, where they accessed one patient, not 3, but 1, and it happened to be a girlfriend of her ex-husband, or maybe it was the other way around. I can't exactly remember. And they were going to use that information. They wanted to know what their diagnosis was. Now, that was a clear violation, not only of HIPAA, but also of our ethical and legal standards. So there are HIPAA violations that are clear, and then there are those, and a lot of them are real muddy, because just because you don't have them on your respiratory therapy worksheet, if the physician were to ask them to do something, just assess the patient, go eyeball the patient or whatever, and the therapist needs to know a little bit about them, well, that's actually what they should be doing. So that's where the policy sometimes can conflict with good practice. So I would make sure you would look at those kinds of things. Here's another HIPAA violation issue. Now, this was very unusual, so I doubt you have this happen very much, but you might have an LTAC within your facility. So, do you have a therapist who works in both capacities, meaning they both work for the LTAC, which is separate from the hospital? And if so, here's what I would recommend. Be very careful, because what this therapist was asked to do is, so they were on rounds with, I believe, yeah, they were on rounds as their in their LTAC position, and they were a consultant. Basically, they would go in and assess patients to determine whether or not they can be admitted to the LTAC, right? So that's what they did. The physician asked the therapist to go look at these patients, and so she did. And when she did, what happened was this individual was tagged because she was working for the LTAC, but she was using her hospital credentials to access the information on the patients. Now, on the surface, you would think, wow, that's a really egregious violation. Well, what happened was no one saw the fact that she worked for both entities and never issued a separate set of credentials. So this individual only had one set of credentials, and that was the only way they could access the information. Now, that doesn't make it right, but certainly it wasn't entirely the fault of the therapist either. They did what the physician had asked. They assessed them, but it was a HIPAA violation because they weren't using the appropriate credentials, which would have a different level of what they could access, obviously. And so it was a real problem. But in this case, all we could do is issue a letter of concern because it was the therapist's responsibility to ensure they had everything they needed. But this was a real go-getter, and they just wanted to do the right thing, and there just didn't seem to be any ill intent involved. But so a letter was sent to the hospital, just clarifying for them, that they needed to check their policy on this to ensure this didn't happen in the future. Because again, there was no ill intent. The therapist did exactly what the physician asked. She assessed. She determined whether or not the LTAC could take them. But she just used the wrong credentials because she only had one set, because that's all she was ever issued. So because it was in the same facility, it was one of those things that, it just slipped through the cracks. Personally, I think it probably should have been looked at a little more carefully as far as that person's termination, because they were terminated from the hospital, not the LTAC, just because it felt a little raw. Clearly there was things that could have happened in HR that someone should have said, and actually it probably would fall back on the LTAC in this case, to say, wait a minute, you need your separate set of credentials. But that didn't happen. Any questions so far? We got a couple more cases. Okay, we'll move on. All right, so the RCP failed to take the ventilator out of standby when transporting a hospice patient. Well, you know what happened. The transport took about 20 minutes. The patient was breathing on a tube without ventilation. Unfortunately, the patient expired once they arrived at the unit. And this one was clear. There was a violation, and it was a mistake. It wasn't an intentional act, but it was clearly a serious violation. It was a sentinel event. It was a policy, ethical, and legal violation for a number of reasons. The therapist, I think, got a little busy and failed to take a few extra steps, such as assessing the patient prior to transport to ensure that they were breathing. They assumed that the ventilator was out of standby when they actually had done the self-test. But this particular ventilator automatically went into standby after the self-test, and they never took it out of the self-test. But the ventilator settings, they had a picture of the ventilator. I don't know why they had a picture of the ventilator settings, but they did. And they showed us what the ventilator settings were, but it clearly showed on the actual photo they gave us, which was self-incriminating, it was in standby. The patient expired within a few minutes after arriving in the unit. But the therapist had already left the unit and gone to actually chart in the EMR. They had written down everything on the ventilator, again, those prior ventilator settings, but they didn't actually check it, and that's why they were terminated. Now, this one was obviously one that we had to address because it was a serious event, and it was a sentinel event. So we did address it, and the hospital has, I think, addressed their policies of transporting patients and those kind of things. So it was unfortunate. But like I said, the therapist certainly didn't have any ill intent. It wasn't anything. It seemed like a very good therapist. All the evaluations were good. All the competencies were good. So sometimes a good therapist does makes a mistake, and that's where we know that it's error is human, right? But we also know that this one could not be. This one had to be addressed, I guess. With either a probation or reprimand. I can't remember which happened. I think it was a reprimand in this case. Well, this one is a common one that you'll see. RCP documents several visits seconds apart in the EMR. And the question is, do you have a concurrent therapy policy? And the answer is yes. And that's why, and they terminate him. So they call me and say, I have a therapist who's doing concurrent therapy, and we've shown in the EMR that they basically did 10 patients in 10 minutes, and so you've terminated him for a policy violation. That's clear, and it's possibly an ethical and legal violation if, in fact, what this person charted was correct. Of course, then we've got another set of problems. But if they didn't, but in this case, they were clearly doing concurrent therapy, and that really wasn't the issue. The issue was it became a false documentation issue because there was no way they were able to do what they were doing as they had written it down. So it went from a concurrent therapy, which we don't have a violation for, by the way. It went to false documentation, false representation, which is much more serious, because under questioning, we found out that they did, in fact, do the treatments, but couple of things, and this was hard to swallow. They charted everybody in the department, so they were allowed by policy to chart outside of the patient area, which I think creates a problem, but I understand why you have to do it sometimes. But they had not written down anything. In other words, we asked the individual, what did you do to make sure you had all the right info? Well, I remembered everything. Well, that meant everything they wrote was potentially fraudulent, because how could you remember 10, let's say you had 10 patients, and you're going to remember all the vitals, breath sounds. I mean, you might remember the drugs because you have that list, but if you don't write it down, how in the world are you going to remember it? And I would never rely on my memory to do that. And their excuse was basically, well, we can't chart in the patient area because everybody's using a computer, so we're allowed to go to the department. I said, well, fine, but you need to have some way of verifying that what you've done, what did you use? And she said, well, didn't use anything. I didn't write it down or anything. I just remembered it. Well, that doesn't fly. And of course, that one definitely constituted a violation, both ethically and legally, because there was no way she could convince us that that she could remember all of that and be legitimate. The reason it was charted a couple of seconds apart was because of the way she was charting and because she went to the department to chart. And so she wasn't actually charting the actual times. So we asked about the times, and the times were made up. So in other words, I guess because the EMR won't allow certain, she had to put like 8 o'clock, 8:01, 8:02, etc. So that's the way she charted it. And I said, well, did you actually give it at 8:02? She said, well, no, but we give it at about, we give treatments at 8, 12, 4, and 8. I said, but that's not the time you gave it. How do you know what time you gave it? And again, that's where sometimes the policy doesn't match what's going on. In her case, they were allowed to do what she was doing, which is chart in the department. The problem was that she used some very bad judgment. So here's the bottom line. Report terminations that are reported aren't all going to rise to the level of a complaint. They may, I'm assuming, all rise to a level of a policy violation. But what you should remember is that we should have a discussion if you have any questions whatsoever on anyone that you've terminated for those, because there might be breaches of both ethical and legal nature that we need to discuss. Sometimes it may rise to the level of a complaint that you have to file, but it may not turn out that the evidence shows anything that we can use, or it might show more. We've had a number of cases where we dig into the file and we have more information than we could ever want, meaning that there were a lot more violations that were more problematic than what the reason they were terminated for. So make sure everything kind of syncs up. Your regulations and standards and guidelines, how does it all fit into the law? Are you allowing them to do things that might potentially open them up for statutory violations, such as giving them too many? I know you have to deal with patient load these days a lot, and you may have no choice but to do concurrent therapy, but do you have a concurrent therapy policy in place to ensure that whatever concurrent therapy they're doing, that they can do it safely? And that's really what the board's position is that making sure that you have information out there for the therapist so they clearly know what's safe to do within your standards, within your guidelines that have been accepted. And remember, to err may be human, but to provide air is respiratory. I know, corny, but that's me. Any questions? Okay, Judy Carpenter. Okay. Judy, just send me a quick email so I'll remember to check you off the list, because it won't show up on the Excel sheet. This might, John, I don't know. Any questions? It's 10:55. I know you're busy. Just let me know if you do have any questions. Shoot me an email. I'm always here to talk to you, and that's why we established the communication network that we did, so we can make sure we keep on top of things. The way this is, I can send you the link and you can use it, but this beautiful AI does not have slides like PowerPoint. They're virtual slides. So, but I can send you the link if that's okay, and that will allow you to show it to your staff. Jim, what's going to happen is I'm going to download the Excel sheet, so you should have your information on there since you've logged in. All right. Well, I thank you for showing up today. I know you're busy, and keep up the good work. I know it's crazy out there. Thank you. All right. I'll talk to you later. Bye.
Thanks.